Imagine losing your health insurance, your food stamps, and finding yourself under federal fraud investigation, all because someone you never even met decided to steal your identity. And the worst part? The person who did it was sitting right inside your doctor's office, with full access to your most private medical records. This is a real story, and it raises a question that could matter to anyone who has ever trusted a healthcare provider with their personal information. Can you sue your doctor if her own employee stole your data? Stay with me, because the answer is more complex and more powerful than you might expect. Let's set the scene. We're in Maine. The year is somewhere in the thick of the COVID-19 pandemic, when the federal government rolled out emergency unemployment benefits to help millions of Americans who had lost income. These programs, including the Pandemic Unemployment Assistance, or PUA, were lifelines for people who had no other options. But like any large-scale government benefit program, they also created an opportunity for fraud on a massive scale. Identity thieves across the country rushed to exploit the chaos, filing fraudulent claims using stolen personal information before legitimate claimants even knew what had happened. For the person at the center of this story, a patient in Maine, the consequences were devastating. They found themselves locked out of benefits they desperately needed, investigated by the government for fraud they didn't commit, and stripped of essential health care coverage and food assistance. And the source of all of this? Someone with access to a doctor's office computer. Now let's walk through exactly what happened, because the details matter enormously when we start talking about legal liability. This patient had at some point been a patient at a medical practice. Like every patient, they had provided their personal information to that office. Their name, address, social security number, date of birth, all of the identifying information that a healthcare provider needs to process insurance and maintain records. That information was stored on the office's computer system, as it is in virtually every medical practice in the country. Here is where things go very wrong. The doctor's son was working as the office secretary. He had access to the computer system, and at some point during the COVID pandemic, he made a decision that would upend this patient's life. He used the personal information he found in that system to file a fraudulent unemployment claim. He collected those COVID benefits in this patient's name, pocketing money that was meant to help real people in real need. The patient had no idea any of this was happening, at least not at first. They may have tried to file their own legitimate unemployment claim and found the system blocking them, because as far as the state of Maine was concerned, benefits were already being paid out to their social security number. The Maine Department of Labor locked the account. And then things escalated rapidly. The Department of Health and Human Services, believing that this person was secretly collecting approximately $1,800 a month in unemployment benefits and simply not reporting it as income, launched a fraud investigation. Think about what that means. This patient was now the subject of a government investigation for fraud. They didn't commit fraud. They were the victim of fraud. But the system didn't know that yet. Because the government believed they had this unreported income, the patient's Mass Health, or in this case MaineCare, which is Maine's Medicaid program, was cut off, no more health insurance, and their SNAP benefits, their food stamps, were terminated as well. We're talking about a person who was likely already in a vulnerable financial position, now suddenly without health care coverage and food assistance, while simultaneously being investigated for a crime they didn't commit. The stress, the fear, the uncertainty, this is not a minor inconvenience. This is a serious disruption to a person's basic safety and well-being. The question this patient is now asking is simple but profound. Can they sue the doctor for failing to keep their personal information safe? Let's break down the legal landscape here, because there are actually multiple potential claims worth examining. First, let's talk about HIPAA. The Health Insurance Portability and Accountability Act is the federal law that governs the privacy and security of medical information. Every healthcare provider is required to implement safeguards to protect patient data. This includes things like limiting who has access to records, training staff on privacy obligations, and having policies to prevent unauthorized use of patient information. If a doctor employs her own son as office staff and gives him unrestricted access to patient records without proper oversight or security protocols, that could very well constitute a HIPAA violation. However, and this is critically important, HIPAA does not give individual patients the right to sue directly. There is no private right of action under HIPAA. What HIPAA violations do create is a regulatory enforcement mechanism through the Office for Civil Rights at the Department of Health and Human Services. Patients can file complaints, investigations can be opened, and the healthcare provider can face significant fines and penalties. But the patient cannot personally walk into court and say, "You violated HIPAA, pay me damages," under that law alone. So where does that leave our patient? The good news is that HIPAA is not the only avenue. State law claims are where this case gets very interesting. Maine, like most states, recognizes common law tort claims that could apply here. The most relevant is negligence. To prove negligence, you generally need to show that the doctor owed a duty of care to the patient, that she breached that duty, that the breach caused harm, and that the patient suffered actual damages. In this case, a healthcare provider absolutely owes a duty to protect patient records. That is well established. The breach, employing a family member with known or unknown access to sensitive data and failing to implement reasonable safeguards. Causation, the son used that data to commit identity fraud. Damages, the damages are very real. Lost benefits, loss of health insurance, loss of food assistance, being subjected to a fraud investigation, and significant emotional distress. There's also a potential claim for negligent hiring or negligent supervision. If the doctor placed her son in a position of trust without properly vetting him or supervising his access to confidential records, she may bear liability for his actions as a result. Beyond negligence, there may be a claim for invasion of privacy or breach of confidentiality. Patients have a legally recognized expectation that their medical records and personal information will not be accessed by unauthorized people for unauthorized purposes. That expectation was absolutely violated here. Maine also has its own state privacy laws and consumer protection statutes that may be applicable. An attorney practicing in Maine would need to evaluate those specific statutes carefully. And let's not forget about the son himself. He committed identity theft and fraud. Those are criminal acts, and in civil court, he could be personally liable for every dollar of damage he caused. The lost benefits, the legal costs of clearing the fraud investigation, and the emotional harm. Now, some people might wonder, does it matter that the patient was a former patient, not a current one? The answer is generally no. The duty to protect records extends to all patient data, past or present. If that information is sitting in the practice's system, it has to be protected. Here is what anyone who finds themselves in a similar situation should take away from this story. First, act immediately. File a police report for identity theft right away. This creates an official record that establishes you as the victim, not the perpetrator. Contact the Federal Trade Commission at identitytheft.gov to start a recovery plan. Notify the Maine Department of Labor and provide documentation that you are the victim of fraud. This is essential to getting your benefits account unlocked and clearing your name. Second, contact the Office for Civil Rights at HHS and file a HIPAA complaint against the medical practice. Even though you cannot sue under HIPAA directly, a formal investigation can support your civil case and may result in penalties for the provider. Third, consult a personal injury or civil rights attorney in Maine immediately. Many attorneys who handle privacy and medical negligence cases offer free consultations. Given the concrete damages in this case, lost government benefits, loss of health insurance, emotional distress, and the burden of a fraud investigation, there may well be a viable civil lawsuit against both the doctor and her son. An attorney can advise on whether Maine's specific statutes, including any privacy or consumer protection laws, open additional doors. Fourth, document everything. Every letter from the government, every notice about your benefits being cut, every interaction with investigators, every expense you incurred as a result of this fraud. This documentation is your evidence, and in a civil case, evidence is everything. Fifth, don't give up. People often feel overwhelmed and powerless when they become victims of identity theft, especially when the system initially treats them like the wrongdoer. You have rights, and this story is a reminder that healthcare providers are not above accountability when their negligence, or the negligence of people they employ, causes real harm to real patients. The bottom line is this: a doctor has a legal and ethical obligation to protect your personal information. When that obligation is violated, whether through direct action or through the negligent supervision of staff, there can be legal consequences. The law does not look kindly on healthcare providers who leave patient data exposed, particularly when the result is identity theft and cascading harm to an innocent person. If something like this has happened to you, if your personal information was compromised by a healthcare provider, an employer, or anyone else entrusted with your data, you need to speak with an attorney in your state as soon as possible. Do not assume that because you are not a lawyer, you have no options. You may have more legal recourse than you realize. And if you found this breakdown helpful, please subscribe to this channel. We cover real legal questions from real people every week, breaking down complex law into plain language so you can understand your rights and protect yourself. Hit the notification bell so you never miss a video, because the next one might be exactly the information you need.